Good morning, good evening, good afternoon, depending on where you're watching from, if anywhere. I am going to have a little fun at the expense of stout, and stout pro se litigants. Because I can. And I have this stupid lingering cough. And this stupid lingering cough is killing me. So I am going to be sucking on a cough drop during the stream. So I hope that doesn't offend you too much. And if it does, well, get over it. All right, so we're going to go up on that. We're going to go up on that. Do I have two of these things? All right. Hello, Weago. Hello, Jeff. Good morning to both of you. All right. All right, so I guess we will start here. This dumbass tagged me in his various community posts because he's not bright. He says, on January 31st, 2023, I emailed Andrew Case, the Latino justice lawyer. He's not just a justice lawyer. He is a Latino justice lawyer representing Sean Reyes, a.k.a. Sean Paul Reyes, a.k.a. Long Island Audit, in the Reyes versus New York case. Mr. Case filed a lawsuit alleging that the NYPD's policy prohibiting filming in police precincts is unconstitutional. Mr. Case filed that lawsuit. That is pretty interesting. I didn't know that I guess the attorney would file it. Yeah. Mr. Case petitioned the court for a preliminary injunction prohibiting the NYPD from enforcing its policy pending the outcome of the case. I emailed Mr. Case, would you consent to the filing of the attached amicus curiae brief in support of the city of New York? I will file the brief now and later notify the court if the parties stipulate to the filing. Now, he's saying this, but we don't know if this is actually what happened, but this is what he's saying. He said, I mailed my amicus, friend of the court brief, to the court presiding over the case. On August 7th, 2023, the court clerk docketed the brief. However, the clerk docketed the brief as a motion or other document filed by me, or as a brief or other document filed by Reyes or Reyes' lawyer. I can't remember exactly what the clerical error was. I didn't screenshot the docket entry before the clerical error was discovered, deleted, and corrected by the clerk. On August 8th, 2023, at 3:41 p.m., the clerk corrected the docket entry. 9 minutes after the clerk corrected the docket entry, Mr. Case responded to my email, Dear Mr. Stout, I did not respond to your email because the city has not yet noticed an appearance, and I was waiting to get their attorney's information so you could seek consent from them since you intended to file in an amicus in support of the opposition. I just saw that you filed your brief and that you marked it as a motion for a preliminary injunction filed by Mr. Reyes. That is not accurate. Once counsel for the city appears in this case, I will consult with them about your amicus. Thank you, Andrew. Mr. Case believed that I had marked my brief inaccurately because the clerk had initially docketed my brief incorrectly. The federal rules require that I ask the court for permission to submit my brief unless all the parties to the case agree to the submission. Well, that's fucking interesting. Which federal rule is that? Because I don't know why he would say that. I don't know why he would say that. I don't know what federal rule of civil procedure he's talking about. I don't know what federal rule of civil procedure he's talking about. So go ahead and stop me when you see anything about filing amicus briefs or amicus briefs. Rule 1 is the scope and purpose of the federal rules of civil procedure. Rule 2 is one form of action. Rule 3 is commencing an action. Rule 4 is summons. 4.1 is serving other process. 5 is serving and filing pleadings and other papers. Let's see if it's in there. Nope, this is just serving and filing. It is not getting consent for an amicus brief or amicus brief. 5.1 is constitutional challenge to a statute. Nothing there. 5.2, privacy protection for filings made with the court. It's not there. It's privacy protection is what you're looking at there. Rule 6 is computing and extending time. It's not that. Pleadings in motion. Maybe it's in here. Pleadings allowed. One form of motion, other papers. Is there an amicus in here? Oh, wait, no, there's not. Disclosure statement. It's not in there. General rules of pleading. Well, maybe it's in here. We'll just pretend. He cites the federal rules of appellate procedure. Okay, well, let's look at the federal rules of appellate procedure. Funnily enough, I already had that up because that's where I would have gone to, right? But he's filing in a district court. He's not filing in an appellate court. So why would you look to the federal rules of appellate procedure? But where does it say in here that if everybody agrees that you can file? Applicability. Rule 29A governs amicus. Okay, that's fine. When permitted, the United States or its officer or agency or a state may file an amicus brief without the consent of the parties or leave of court. Any other amicus curiae may file a brief only by leave of court, or if the brief states that all parties have consented to its filing, but a court of appeals may prohibit the filing or may strike an amicus that would result in a judge's disqualification. So that appears to be what he is citing to. So he's trying to get all parties to consent to the filing. Now, again, notice that it is a appellate federal rule of appellate procedure, so it doesn't apply to the. I don't know if there's a requirement to that. You know what? We could actually check. I don't see GMK where it says that it has to be filed by an attorney. But you'll notice in here that he has only asked one attorney. He has not asked both attorneys, and he did not have consent of either counsel. He did not have consent of either party before he filed it. So even if the federal rules of appellate procedure applied, which they don't, even if they applied, then he would still not have done it correctly. Federal rules require that I must ask the court for permission to submit my brief unless all the parties agree to that submission, because everyone was pretty much on the same page at that point. Now, who is everyone? Now, he has said that he's talked to Andrew Case, but it was filed before he got any response from Andrew Case. So he did not have the consent of Andrew Case. He hadn't even contacted the city's council, so he definitely didn't have their permission or their agreement. So this is a fucking lie. I mean, he's straight up lying right here. This is a lie. And because I know, how do you know that? How do you know the judge read the brief? How do you know the judge read the brief? Does judge mention your brief? Some district courts have local rules allowing for amicus brief, like DC district, but otherwise it isn't really covered and can only be done by leave of court. You know what? I would say that you need to look at the specific district. In this case, it'd be the District of New York, Southern District of New York, to figure it out. While you're busy Googling, I will continue to read. But he doesn't know the judge read the brief. He wishes the judge read the brief. He says, I slowly forgot about Reyes' case or further reached out to the parties about the brief. You've already filed it. It was filed. It was filed without permission of the court. Jasper Kalin, hey, we have the man, the myth, the legend himself. Stout filed his amicus brief in LAA's civil trial without requesting leave to file. That is a correct statement. And the clerk misfiled it as coming from LIA and left it on the docket. Interesting. So he's saying that it was corrected. but it was filed. It was misfiled. It's coming from LIA. That is correct. And it was left on the docket. That is also correct. So the only thing you could possibly say in here that is going to rebut what Jasper Kalin said is, and it wouldn't rebut it, it would just further expand on it, is that it was modified by the clerk to show that it Alpha Fox Adam getting his digs in. So he didn't say, so there's the difference between the legal memo and the amicus curiae brief. Again, Stout does not address the issue. He's just, oh shit, you can't see this. Share this tab instead. So this is what we're looking at. So there's Jasper Kalin, and it does show here Mark Stout's amicus curiae brief in support of the city of New York. You know what? Let's do a little inspect what you expect. And yeah. So it apparently was corrected to show Mark Stout's amicus curiae brief. So, I mean, that's one way of getting your name in the lights. Oh, my cock is fine. You have to really put your face close to my cock to be able to hear it. It'll whisper in your mouth. Good morning to you, Chris H. Just to be safe, I recently mailed my motion for leave to file my amicus brief to the court. My motion has not yet been docketed. Well, I don't see that. I don't see that that's made it. Let's see. Let's see if 13 hours ago. So it was last updated. Recap was last updated 13 hours ago. So I don't think anybody's updated anything since. But let's just see here. So it looks like last docket was 26. There's a couple orders filed after that. But we'll check it out. We'll spend the money for you guys. Nope. All right. So so if you did mail a letter, it has not made it into the docket entries. So depending on when he mailed it, the court might just be ignoring it. So he says recently. When is recently? Who knows? However, the court had since received all the other parties' arguments and taken the preliminary injunction into consideration. While I shouldn't have forgotten about Reyes' case, and while I should have filed my motion for leave to file my amicus brief sooner, considering the circumstances, I don't think it really matters whether or not I now obtain formal permission from the court to submit a brief that the court has already read. Well, you don't know the court has already read it. That is an error on your part to think that the court has already read it. You can see what I'm reading, sir. I see it on my screen, meaning that you can see it on your screen, because I have two screens going at once. Well, yeah, I'm not faulting you, Jasper. I'm saying that he's a fucking dumbass. So when I submitted my amicus brief to the clerk, it was attached to a cover letter. The cover letter reflects I requested the clerk to file my amicus brief and mistakenly my motion for leave to file my brief. I did not actually submit the motion with the brief because I'd already communicated with the parties. Again, by his own reflection of the accounts here, he had emailed or mailed. He had emailed the plaintiff's attorney, but he had no contact with the defendant's attorney, and he had not heard anything back from the plaintiff's attorney. So he's a fucking lying piece of shit. What would you expect out of someone who's a career criminal? But he's a lying piece of shit, and he had not communicated with the parties. So it's not that I didn't know; it's that I didn't do. It's you're a dumbass. You didn't know, and you didn't do because you thought you could just get the parties' consent, and you thought you could rely on the rules of appellate procedure in a district court case. But they're called different things for a reason. It's because they're for different courts. One is for the Court of Appeals. The other one is for the district court. Individuals are claiming in their comments posted to Murby's live chat that I filed my amicus brief without requesting leave to file. That is correct. You did not request leave to file, at least not from the court and not properly, and you didn't get leave to file. That the clerk left the clerk's error on the docket. I don't think anybody really cared about that. I don't think anybody cared about that. That's a non sequitur. That's one of those things where you throw in there just so you can see I was right. It's a straw man argument. Everybody's arguing this. Well, no one argued that, but I was right. Like it's a straw man. That's literally a straw man. It's a way for him to say, but I was right. Well, go have yourself a morning margarita. If you're having morning margaritas, you may be an alcoholic. I'm just saying. Check with Coded to be sure. Check with Coded to be sure. That I tried to represent a woman. That was Alpha Fox Adam. And I have no reason to not believe Alpha Fox Adam. And that I was told that I was engaging in the unauthorized practice of law, and that Pepperidge Farm remembers. Oh, that Pepperidge Farm doesn't remember, therefore I'm right. What a dumbass. The first claim, image one, is a complete and entire fabrication, except you filed your amicus brief in the civil trial. That is a true statement without requesting leave to file. Well, technically, you requested an agreement to file, not leave to file. Leave is something the court will grant. Plaintiff's attorney does not grant leave. Does not grant leave to file. That's something the court does. So you're stout. You're wrong. And the clerk misfiled it as coming from LIA. That is another correct statement, and left it on the docket. That's another correct statement. You can even see it on the docket right here still. So everything that Jasper Kalin said is 100% correct. I don't think you would win considering your particular skill with filing lawsuits. So now let's go on. I'm going to ignore this. All right. Then there's this one. On April 5th, 2023, a federal district court ruled in my Stout versus DEA lawsuit. So this is Frauditors Exposed when he sued the federal government on a Bivens claim for frauditing, right? Everything that he claims to hate, he's done. And now just because he lost, he's like, oh, I meant to do that. What a fucking asshole. Plaintiffs, quote, plaintiffs allege defendants interfered with their effort to film the interior of the DEA's publicly accessible lobby for news purposes. That court ruled that my lawsuits were so powerful. This is the particular lawsuit. This is the order. And we're going to Control F. We're going to do plaintiff. So you can see that word search works because I just typed in plain and I got plaintiffs, right? So I'm going to back out of this and we're going to look up powerful. That's powerful. Nothing comes up. Powerful does not appear in this docket or in this document. So let's continue reading, I guess, because this lying motherfucker is lying again. The court ruled that my lawsuits are so powerful, he says, lying out of his ass, so powerful that you lose, that, quote, plaintiffs' claims would widen the scope of government employees amenable to suit for their official acts and would likely deter individuals from seeking these types of positions in our government, end quote. You don't see that. Now you see that. I remembered to mute the mic that time. You're welcome. So what is it talking about? Well, let's go to Ziegler versus Abbasi. This is a United States Supreme Court case from 2017. So as you could probably tell from Stout versus DEA, he is suing the agents for the federal government. 42 USC 1983 allows you to sue state actors or people acting under color of law. But it does not allow you to sue federal actors. It does not allow you to sue FBI agents or DEA agents or FPS agents. So what happened was there was a case, Bivens versus 6 FBI agents or something like that. I forget the exact title of it, but it was where a plaintiff sued under it was just a Fourth Amendment case, Fourth Amendment search and seizure violation case. And the court back then said, you know what, you should be able to sue for money, and so they allowed that suit to go through. Since then, a Bivens action has become disfavored. The court has basically said, you know what, we probably should leave that to Congress, because the United States has sovereign immunity, and while we can definitely say whether or not there is or should be equitable relief, Bivens versus 6 unknown named agents, yeah, something like that. While we could definitely give equitable relief, money damages, things like that, giving a cause of action, giving a tort cause of action that basically pierces the United States sovereign immunity, is probably something that we should leave to Congress. Congress should be the ones who determine whether or not you can sue the United States for money for a particular thing. So Bivens has been very limited since then. There's like 3 or 4 separate causes of action that you can sue for on a Bivens cause of action that the court will recognize. Everything else is going to go through a series of tests. The proper test for determining whether a claim arises in a new Bivens context is as follows. If the case is different in a meaningful way from previous Bivens cases decided by this court, then the context is new. I think the court goes over here the cases where it was new. We're going to show this tab instead. All right, so Bivens, Davis, and Carlson. So Bivens is a Fourth Amendment violation. Davis is a cause of action where a plaintiff raised a Fifth Amendment equal protection claim alleging gender discrimination in congressional staff employment. And then Carlson versus Green recognizes a cause of action where plaintiff raised an Eighth Amendment cruel and unusual punishment claim related to medical care. related to medical care in a prison setting that caused the inmate's death. So those are the known and available causes of action. Everything else gets scrutinized. So what the next thing you have to do is look for meaningful differences, and meaningful differences may include the rank of the officers involved, the constitutional right at issue, the extent of judicial guidance for the official conduct, the risk of disruptive intrusion by the judiciary into the functioning of other branches. The risk of disruptive intrusion by the judiciary into the functioning of other branches, or the presence of potential special factors not considered in the previous Bivens cases. So what the court does is So what the court is going to do here is the court is going to be looking at all these various things and finding that there are meaningful differences. The court finds that there is a risk of disruptive intrusion by the judiciary into the functioning of the other branches. And then the court is going to look at special factors. And it's when the court is looking at special factors, the first special factor against a new Bivens remedy, i.e., apologize about that. Apparently, this cough is going to linger for like a month or something dumb. Yay, coof. I guess the first time you get it is the roughest time. All right. So the first special factor weighing against the new Bivens remedy is that plaintiff's complaint deals with defendants carrying out federal policies, specifically the policy requiring visitors to a federal facility to submit to security screening and the policy prohibiting loitering and disorderly conduct. When plaintiffs challenge the implementation of general federal policies like the ones plaintiffs challenge, it counsels against applying a Bivens remedy. Okay. Another special factor for the court to consider, so this is the second special factor, is the impact on government operations from an expansion of Bivens remedy under the facts of this case. A Bivens expansion would seriously hinder the government's ability to secure its facilities and ensure disruptive behavior does not impede the work of the building's government employees. Further, so this is the final special factor, plaintiffs' claims would widen the scope of government employees amenable to suit for their official acts and likely deter future individuals from seeking these types of positions in our government. This special factor also counsels against the recognition of a Bivens remedy. So remember what he was saying. He was saying that the court ruled that my lawsuits are so powerful that, quote, plaintiffs' claims would widen the scope of government employees amenable to suit for their official acts and likely to deter future individuals from seeking these types of positions in our government. But that's not what the court said at all. What the court said was that this special factor, i.e., if we granted the relief that Stout was requesting, that it would essentially impact the ability of the federal government to retain police officers. It was probably FPS agents that were protecting the DEA's lobby. It might have been DEA agents, but it was probably FPS agents. Who knows? I'm speculating. And he goes on to say, you will never hear any court state that any soft, weak frauditor, especially Reyes, could ever deter anybody, especially a government employee. Well, so the court didn't say that Mark deterred anybody. That's not what the court said. The court said, if we allow this particular cause of action, if we say, okay, under Bivens, you can sue these people, then it may determine or deter future individuals from seeking these positions in our government. So it has nothing to do with Mark. It just has to do with Mark's cause of action being not within the scope of Bivens. That's all the court's saying. Not only do frauders not deter or scare anyone, they are shark chum to someone who can deter or scare somebody. Tough guy Mark Stout thinks that he is deterring or scaring someone. Too bad the court didn't say that, Mark, you fucking idiot. Too bad the court didn't say that. The court ruled that individuals may not sue federal employees for violating an individual's right to film or for violating the federal DHS memo. The court did not rule anything about violating the federal DHS memo and dismissed my lawsuit. So he's desperately trying to turn a serious fucking loss into a win. As promised, he says, I've become another case against frauditors. As many here know, I've been planning that case outcome for over a year. Fucking wow, dude. He worked for a year to lose. That's fucking amazing. He worked for a year to lose. And then he says, here's a link to the docket. And he links to pacermonitor.com. Now, for those of you who don't know, this is Pacer Monitor. And Pacer Monitor is a pay-to-play site. If you want to download this, you have to pay. Instead, you could go to the court listener site, where as long as someone has paid for the I just bought the last document. There we go. So see, I just bought this with recap. And now if you want to, you can download the order yourself, just so you can see how fucking stupid Mark Stout is. Because Mark Stout is really fucking stupid. Thus ends the Mark Stout portion of this proceeding. I don't want to lump them all together. I don't know who they is. All right, so let me close some things off. Oh, hold on a second. You know what? There was one other thing that I wanted to talk to. So, this is a letter, a request to file an amicus brief in the Southern District of New York. Southern District of New York. A request to file an amicus brief. So you'll say, pursuant to the court's individual practice, yada, 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 blah, blah, blah. Here's the letter. And then what they've done is they've attached their proposed memorandum of law of amicus curiae plaintiff settlement class in blah, 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 in opposition to defendant's motion to dismiss the complaint. Right? This is what it's supposed to look like. Table of authorities, blah, blah, blah. Table of authorities. This particular authority right here is the interesting one. Why is it the interesting one? Well, let's fucking find out, shall we? This is page 3 of the proposed amicus curiae brief. Proposed amicus curiae brief should be granted leave to file. See, granted leave. Granted leave. What does leave mean? Leave is something the court gives you. It's not something that plaintiff's counsel can give you. Leave is something that the court grants. This court has noted that, quote, there is no governing standard, rule, or statute prescribing the procedure for obtaining leave to file an amicus brief in the district court. What? I thought that Stout looked up the federal law. I thought Stout knew all about this, right? Nonetheless, this court looks to cases interpreting Rule 29 of the Federal Rules of Appellate Procedure for guidance. In this respect, an amicus brief should normally be allowed when a party is not represented competently or is not represented at all. When the amicus has an interest in some other case, it may be affected by the decision in the present case, or when the amicus has unique information or perspective that can help the court beyond the help that the lawyers for the parties are able to provide. None of which Reyes brings to the table. Not Reyes, Stout. Stout has no unique information. Stout has a shitty generic memo that he doesn't fucking understand, that he mails to everybody and apparently files in cases willy-nilly. So this is the proper way to do it. This is not the way that Stout did it, and therefore Stout's a fucking retard, but we already knew that, right? We already knew that. All right, so now we're going to go back to close, 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 close. All right. Now we're back to we're back to Springer versus 7th Judicial District Court. We did 56 last night. It was fucking tragic. No, we did 55 last night. Oh boy. And 55 was tragic. This Blair Dunn guy, who's going to win what? Well, at this rate, it's a battle of idiots. the defense attorneys don't seem to be capable of writing coherently, and plaintiff's attorney doesn't seem to be able to write coherently. So I don't know. It's going to be fucking hard. I'm sorry, Papa Sanser. I'm sorry, but we're going to go through it some more. You can, I don't know, go watch fish room videos or something while we're doing this. But we're going to do it. We're going to do it. All right. Oh, okay. What the fuck? What the fuck did I just... Hold on a second. Springer versus 7th Judicial District Court. What in the fuck? All right. So I'm in Springer versus... I'm in Springer versus 7th Judicial. So I click on 56 download PDF. And I get George Douglas Metz II. That's Rogue Nation. I get his complaint. Fucking hell. $56. That's the correct one. All right. You're welcome. I like paying for this crap for you guys. Makes me happy. All right. So this is 56. And this is reply in support of opposed motion for stay and injunction pending appeal. Is this still Blair Dunn? This is a different writing style. Well, you know, I mean, I'm not judging Springer in this, and I'm not judging Reyes in any of his cases. I'm looking at the pleadings. I'm looking at legal pleadings. So, I don't know that I've called Springer a loser, nor do I believe I've called Sean Paul Reyes a loser. So I don't know why you would think they would care. And you know, when I do criticize, I've criticized Freeman often. And when I do criticize him, what he can never do is he can never tell me that I'm wrong. And because of that, he decided instead of engaging me and just being wrong, he decided to not engage me anymore. And that's fine. He doesn't have to engage me. Well, I haven't opened that other case, the Mets case. I know who he is, but I've never opened up that case. So, but anyway, yeah. So the one thing that Freeman can't do is tell me I'm wrong. And well, he can tell me I'm wrong, but he's not right when he does it. He can't actually prove me wrong. I think Mark and Chili value Merv's opinion. Well, I know Chili does because Chili has sent me stuff to get my opinion on it. So yeah, and Mark keeps tagging me. So evidence suggests. All right. Nothing against James Freeman, but I think Long Island Lots is more attractive. Well, Jesus Christ, nasty Nathaniel. Keep your cock in your pants for a minute. All right. So it comes now. This is the reply in support of opposed motion. We're going to hope that he was sober. The attorney was sober when he wrote this one, and he spell checked it. Comes now plaintiff through undersigned counsel with reply in support of his request for this court to issue a stay of proceedings before the court and injunction barring that the defendants may take no action to prevent plaintiff's free exercise of his rights to speech, press, and to petition the government for redress during the pendency of the appeal and for his reasons states. That's new. That's not a. Well, I don't believe a word you say because you say that you carry two bar cards, and I've never seen you say anything that would ever suggest to me that you're an attorney. You're funny, and you put things out that are kind of interesting in a that's kind of funny way, but you've never shown any aptitude with the law. So I'm going to press X to doubt. Yeah, James is a good looking dude. I'm not saying I'd do him, but he's a good looking dude. So, as noted by defendants, the court considers the following four factors when considering a motion to stay during pending appeal. One, whether the state applicant has made a strong showing that he's likely to succeed on the merits. The court has already found that the plaintiff is unlikely to succeed on the merits. Two, whether the applicant will be irreparably injured absent a stay. The court has already found that there will be no irreparable injury absent a stay. Go ahead and send them to me. My DMs and my email are unless you're chilly. I don't publish this shit. Well, I've published some other things. Like if you send me something that's just fucking hilarious, like where you want to rant at me, I might post that. But if you send me personal information, I won't. So send it to me. Prove it. Put your money where your mouth is. I haven't leaked my DMs with shiz, so I'm not a DM leaker. Post it. Post that shit, son. Y'all even open up Discord. My body's ready. My body's ready, GMK. Prove it. All right. 3, whether the issuance of the stay will substantially injure the other parties interested in the proceedings. I don't believe the court has specifically ruled on this particular one. Then what's the end game? I don't know. Then I'll believe you. Until then, I won't. Like as simple as that. Whether the issuance of the stay will substantially injure the other party's interest in the proceeding. The other parties have alleged that James Freeman's actions in the court were disruptive of the court. He was violating local court rules, and he was causing an environment that the employees found to be hostile. Right, and I don't know if the court will find that substantially injures, but I strongly suspect that a court will find that disruption of court proceedings will be substantially injurious to the court. Because you got to remember that first incident with Freeman and the DCSS slash DV judge, not judge, commissioner, whatever they call him out there. His interaction with that guy was, the guy was like, "Hey, you need to put on a mask." And instead of putting on his mask, Freeman starts filming, or was filming already, and starts challenging the guy. And the whole challenging a judicial officer in the courtroom disrupts the courtroom. And so I can't. You're welcome, JTL. You're welcome. So I assume that a court will find that the district court will find that allowing Freeman to continue to disrupt judicial proceedings, it will substantially injure the operations of that court and those defendants. Well, you don't know many attorneys, so you're like, I'm an expert on attorneys. Yeah, you're like, you're not. And then 4, where the public interest lies. The public interest lies in the efficient administration of justice. So I don't think any of these 4 factors weigh in favor of the stay pending appeal. With respect to the 4 stay factors, where the moving party has established that the 3 harm factors tip decidedly in his favor, the probability of success requirement is somewhat relaxed. Yeah, decidedly, and I don't think he has. If the movement can meet the other requirements for a stay pending appeal, they will be deemed to have satisfied the likelihood of success on appeal element if they show, quote, questions going to the merits so serious, substantial, difficult, and doubtful as to make issues ripe for litigation and deserving of more deliberate investigation. Interesting. Let's look at that in context. Where's the full citation? He doesn't even give a full fucking citation. Did he cite it below? So we have to fucking guess. We have to fucking guess on this. Christ on a motherfucking cracker. Christ on a motherfucking cracker. This appears to be it. It may or may not be it. At 10:20, he says. All right, so the first issue that we have is we're looking at a circuit court looking at a stay pending appeal. This is the circuit court, and it is making reference to the federal rules of appellate procedure. Federal rules of appellate procedure. So this case is a circuit court judge, a court of appeals judge. Federal rules of appellate procedure. Federal rules of appellate procedure. So this is what a circuit court judge would look at in determining whether or not a circuit court judge would grant a stay pending the outcome of the appeal. So 10th Circuit Court, this is the circuit court rule, this isn't the district rule. This isn't the New Mexico District Court rules of local rules. This isn't that. This is a different court's local rules. Oh no, you don't find me attractive. Oh no. Oh no, some random dude on the internet doesn't find me attractive. Dude, that hurts so bad. That hurts so bad. I'm going to go cry. So again, so we're wrong court, wrong rules, not just local rules, but rules of procedure. One's using the appellate rules of procedure. The other one's using the federal rules of civil procedure. So their local rules, or the circuit court's local rules, require an applicant to address the following: a likelihood of success on appeal, the threat of irreparable harm if the stay or injunction is not granted, the absence of harm to an opposing party. I don't fucking care, dude. Like, it really doesn't bug me. And apparently a female, allegedly, because there are no females on the internet, thinks that I'm attractive. So now what? Now what, homebro? Now what, homebro? Thank you, Papa Sanser, for calling me a living jump scare. I appreciate that. So let's go back to this bullshit here. So the court, it's not the court, the Court of Appeals would consider the following factors. And So he's citing the wrong fucking test in his reply brief. This attorney sucks ass. Like why is it that in 10 seconds of looking at this, I'm like, oh shit, this is talking about federal rules of appellate procedure. This is looking at the local rules for the circuit court, not the district court. This is what their local rules require, not what the federal rules of civil procedure require, not what the New Mexico District Court local rules require. And it goes on to say the defense counsels complied with the 10th Circuit Rule 8.2. Counsels also complied with 10th Circuit Rule 8.3. Federal Rule of Appellate Procedure requires the application for say must ordinarily be made first in the district court. That's stupid. This is fucking stupid. As noted by the defendants, the court considers the four following factors. So, did the defendants cite to McClendon? Did the defendant cite to McClendon? Oops. In their opposition, they would call it a response. All right. So this is their response. So they quote McClendon as the purpose of a stay is to preserve the status quo pending appeal. That's fine. I don't have a problem with that. Rule 62C, while an appeal is pending from an interlocutory order or final judgment that grants, continues, modifies, refuses, dissolves, or refuses to dissolve or modify an injunction, the court may suspend, modify, restore, or grant an injunction on terms for bond or other terms to secure the opposing party's rights. These federal rules of civil procedure. So they're citing to the appropriate federal rules of civil procedure. Rule 8.1a of the Federal Rules of Appellate Procedure provides that a party must ordinarily first move in the district court. That is also correct. The court considers the following four factors when considering a motion to stay pending appeal. And we're looking at 776. Different rules of procedure govern the power of district courts and courts of appeal to stay in order pending appeal. See Federal Rule of Civil Procedure 62C and Federal Rule of Appellate Procedure 8A. Under both rules, however, the factors regulating the issuance of a stay are generally the same. So these are the things that are the same between the two of them. Okay? Okay. Oh, they fucking did the same thing. Oh, Jesus Christ. Two fucking. Drive what? Drive golf balls? Let's go back to McClendon, I guess. Maybe I'm the dumb one. You know what? We're going to do this. We're going to do this. We're going to do this, what I like to call the right way. Found it. They all cut and paste from here. So they didn't cut out the part, the McClendon, the full site. Oh, so the defense counsel did. The defense counsel just ripped this entire fucker out. Just boom, cut and paste. But then when plaintiff's counsel did it, he cut and paste, but he did not include the initial site. Here, the court ruled almost exclusively that the request for injunctive relief failed because plaintiffs failed to establish a substantial likelihood of success on the merits. That's where the court could stop, because once the court showed there was no once the court found that there's no substantial likelihood of success on the merits, the you fail on one, you failed. So the court didn't have to continue. Because the court has not disagreed with the actions of defendants to exclude plaintiff from his free exercise of speech, petitioning, press, or irreparable harm, the defendants have not demonstrated harm to them is likely because of the outside the two initial and minor violations of court rules. So he calls them minor. The defense now claim they initially claim his ban was because unknown persons called and complained to the court on his behalf. See ECF Docs 1-1 and 1-2. But they, I mean, did they sign those under? Did they sign those under penalty of perjury? I don't know. That's very loud and annoying. Because outside the two initial and minor violations of court rules, i.e., filming in court, against the local rules and the failing to wear a mask when it was required by the court. But that's not all that they alleged. They also alleged that that he harassed the clerks and things like that, etc. They initially claimed his ban was because unknown for let's look at that. Let's fucking look at it because it's gonna bug me if I don't. ECF docs 1-1 and 1-2. Shall this tab instead? Attachment 1, Exhibit 1. All right. So this is 1-1, document 1-1. Matter having come to the attention of the court being fully advised that the interest of safety and security of judges, special commissioners, hearing officers, and other court personnel is therefore adjudged and decreed that he's banned from entering unless appearing for having specific court business, in which case he shall be escorted and accompanied by the Torrance County's Sheriff's Department. It is further ordered, judged, and decreed that upon entering, he has to identify himself, yada yada. Nowhere in there does it say anything about what was it? What was he saying? They initially claim his ban was unknown persons called and complained. So let's look at ECF Doc 1-2, shall we? ECF Doc 1-2. As the CEO of the 7th Judicial District Court, has been brought to my attention the court staff are being harassed on your behalf and has impacted court resources. The court issued an administrative order on March 1, 2023, and you're required to be in court, if you're required to be in court or have official court business, you'll check in, yada yada. So he just says it's been brought to my attention. Okay. Took you that long? I love it. I love it. So go back to this. They initially claim his ban was because unknown persons called and complained to the court on his behalf. See ECF Docs 1-1 and 1-2. This is like a full fucking chili. This is a full fucking chili. Because here's ECF document 1-2. Nothing in here about unknown persons calling. It just says it has been brought to my attention that court staff are being harassed. It's been brought to his attention. He might be the court staff who's been harassed. It came to the attention of the court. There's nothing in here about being called. So I don't fucking know what this dude's talking about. And that's why you inspect what you expect. Because I expected he was fucking wrong. They called on his behalf to complain. Oh, that's not an ECF Docs 1-1 and 1-2. Let's go back to, let's look at, share this tab instead. Let's look at Exhibit 3. Nothing there. Let's look at Exhibit 4. Nothing there about phone calls. Let's look at Exhibit 5. Nothing in there about phone calls. Let's look at this exhibit. Nothing in there about phone calls. Let's look at this exhibit. Nothing in there. Let's look at their response. Oop, I didn't want to click that. Let's look at their response. This is the Bennett issue. Mask mandate. Refuse to comply with court orders. Preservation letter. Legal argument. Refuse to call, cell phones, disruptive behavior. Call does not appear in this document. All right. Motion to disqualify, motion to set aside default. Response to motion to set aside. Well, let's look at this exhibit. This is exhibit 48-1. I hate attorneys with giant shitty fucking signature blocks, because like when you reply, and you end up with like 30 pages of signature blocks down at the bottom. It's fucking annoying. Even this signature block here is annoying. Like you don't need a signature block that long. Like, do you really need their email? They've just fucking emailed you. Do you need to have their email in there? Fucking Christ. So there's nothing in there about it. Okay, exhibit 2. This motherfucker. Please share a copy of the complaint with the other defendants. Oh, this motherfucker's trying to serve this shit by email. Oh my god. Oh my fucking god. I just tried to serve his shit by email. Oh, holy fuck. Oh, that's comical. Ah, that's fucking hilarious. He tried to serve him through Odyssey. Odyssey is like a filing system. Oh, Jesus Christ. Oh, oh my god. Look at how this dumb motherfucker's trying. Oh, fuck personal service. Oh, Jesus fucking Christ. Please acknowledge that you received this so I can say that you did. Because I'm too fucking dumb just to have a someone serve it, a process server serve it. Anyway, I don't say I'm getting lost in the weeds. But anyway, uh, I don't see where they initially claim his ban was because unknown persons called. They've had a lot of reasons. Well, like on my personal ones, I just have my name at the bottom and my phone number. That's it. Like, because if you're gonna respond by email, you're just gonna reply, and the only other thing that you would want to do would be to call me to talk about the email or whatever. So that's the only information I put in there. And if you need more information, you have my fucking email address, and you have my phone number at that point. So you could fucking figure out how to get more information if you need it. If you need to mail me something, you could figure it out at that point. All right, so let's try this long sentence again. All right, this appears to be one sentence. This appears to be one sentence. That's one sentence. This is what you don't do, kids. This is what you don't do. This is one sentence. I'm going to read it without all the internal citations. Thus, because the court has not disagreed that the actions of defendants to exclude plaintiff from his free exercise of speech, petitioning, and press are irreparable harm, The defendants have not demonstrated the harm to them is likely because outside the two initial and minor violations of court rules, the defendants now claim the initial claim his banned was because unknown persons called and complained to the court on his behalf, form the basis for their justification in stripping away fundamental liberties, or that injunction is adverse to the public interest because court must recognize the 10 Circuit's holding that it is always in the public's interest to prevent violations of a person's civil rights. This court must apply a relaxed standard to the probability of success standard and should grant the stay and injunction pending appeal. I'm not even going to bother to parse that. I think he's just saying that the court should grant stay and injunction pending appeal because of a relaxed standard. The problem is that while the court didn't make a specific ruling on it, what the court is going to find, because the court's going to make a finding in whether or not to grant this one. And if the court has to get past this point, which I don't think it does, because the moving party has to establish that the three harm factors tip decidedly in his favor, and the court has already found that one of them does not. So you lose already. You're losing already. But number two is whether the applicant will be irreparably injured absent a stay. If the court needs to make a ruling on it, the court will, and I strongly suspect the court will rule against Freeman at this point. And whether the issuance of the stay will substantially injure the other party's interest in the proceeding, I suspect the court will find this tips against Freeman. And then where the public interest lies, I suggest to you that the court will also find that this tips against Freeman. All right, we're going to close that. We're going to close that. We're going to close that. All right, that was 56. 27 pages, for Christ's sake. I don't know if I'm going to make 27 pages today, kids. I don't know. We're going to try, I guess. All right. Defendant's motion to dismiss plaintiff's complaint for declaratory judgment and injunctive relief for civil rights violations under 42 U.S.C. section, no sections given, because why the fuck would you proofread your goddamn motion to dismiss? Violation space S of rights protected by the New Mexico Civil Rights Act, emergency request for a temporary restraining order, request for a preliminary injunction, permanent injunctive relief, and damages. Comes now, defendants, yada, 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 bind through their counsel, yada, 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 and in lieu of an answer, hereby moves to dismiss plaintiff's complaint for declaratory judgment. And again, the same mistakes in here. Under 42 U.S.C. section, nothing. Violation space S again. Why spell check? Why proofread? Introduction. This action arises from an incident that occurred on January 27, 2023 at the 7th Judicial District Torrance County Courthouse. On that day, James Stringer, plaintiff, interrupted a hearing already in progress without a mask as required by state mandate and snuck a cell phone in the courtroom to secretly record his visit. As a result of plaintiff's misconduct, Chief Judge Mercedes Murphy entered an administrative order and amended administrative order, collectively administrative orders, limiting plaintiff's presence in the 7th Judicial District Courthouse to his own matters or specific court business, and with a law enforcement escort. On June 29, 2023, plaintiff filed his complaint for declaratory judgment. Okay. Now they have piqued my curiosity. No. So he had 1983. So he had it right. They didn't. And count, like, are they trying to fuck this up? Because they had to retype it. See, this is all in caps. And so they didn't just copy and paste this. They retyped it. They retyped it with the same errors and omissions. Fucking crazy. Fucking crazy. In count one, he alleges a claim predicated on violation of the First Amendment, freedom of speech and press. 2 is substantive due process. 3, procedural due process. 4, violation of Article 2, Section 17, 18, and 23 of the New Mexico Constitution against the 7th Judicial District Court only. He seeks declaratory judgment of the administrative orders are unconstitutional and further requests a temporary restraining and preliminary injunction and permanent injunction prohibiting defendants from enforcing the administrative orders, actual punitive damage, etc. They seek it for the following reasons. Defendants are entitled to dismissal based on lack of proper service, lack of jurisdiction, spoliation of the evidence. We have a kitty. We have 2 kitties now. And I see one of the kitties. I'm not a cat fan, but I still want to pet the kitty. He's still young and playful. He's just playing over there. Fun stuff. Further, all claims against Mercedes Murphy, Shannon Murdoch Poff, Jason Jones, and Susan Rosenthal should be dismissed because plaintiffs are entitled to qualified immunity. I think they're entitled to judicial immunity. I could be wrong. It is judicial immunity, not qualified immunity. I don't know why. I want to stroke. I want to stroke the pussy. Yep, you kitty kitty. Morty is ignoring me. Typical cat. We have Morty and Melvin. Morty is a striped gray male, and Melvin is a black male. There's a kitty. There's a kitty. Oh, kitty. You ignoring me? Well, there's your... I have now shown you pussy on my live stream. Enjoy it. All right. Plaintiff's complaint does not assert any factual allegations against any 7th Judicial District official employee upon which relief can be granted. Finally, because plaintiff's federal claims fail, this court should decline supplemental jurisdiction over plaintiff's state law claim. Court must dismiss a 12B6. Yada yada. Factual background. At the beginning of 2023, state of New Mexico had a mask mandate for all its courtrooms. This is basically requesting judicial notice, which the court will do, probably. On or about January 27, 2023, plaintiff entered a courtroom at the 7th Judicial District Court to observe a hearing before hearing officer Gordon Bennett. Document 25-2. 29 Exhibit A and 29 Exhibit B. 25-2, let's just make sure that 25 and that was 25-2, the Springer Declaration. Okay, that's fine. That's a good site. 29 Exhibit A and 29 Exhibit B. 29. 29, Exhibit A, and 29, Exhibit B. So they're saying that these are YouTube videos. Hmm. Not in my butt crack, no. At least not that I've been aware of. Court may or may not take notice of those. Plaintiff posted videos of his interactions with H.O. Bennett on his YouTube channel. Document 1, paragraph 14. Document 1. Oh. So they're hoping for incorporation by reference. Okay, that's a valid thing to try. And then document 25-4 and 38-4. 25 paragraph 4, I'm going to guess. No. What are they talking about? 25-4. What is 25-4? What is 25-4? I'm assuming they meant 25-2, but they're fucking idiots. But they're fucking idiots. That's really the problem, is they're fucking idiots. ZNM. So this is the one that they put as a footnote instead of referencing to it that we just went over. And then MR lowercase s 0. And the other one, MR lowercase, that one's not in here. And then 38, page 4. 38. Amended order? Ah. Interesting. Okay. So the court has already noted it for some reason. From somewhere. At this hearing, H.O. Bennett asked plaintiff to put on a mask, identify himself, and whether he's recording with a cell phone. Plaintiff refused to put on a mask, identify himself, and confirm he was recording with a cell phone. Bennett warned plaintiff if he continues his misconduct, he may charge plaintiff with contempt. Plaintiff left the courtroom saying he'd be back. Plaintiff asked Torrance County Sheriff's Office whether they'd be enforcing the mask mandate. Who responded, "We're not going to enforce a mask mandate in the courtroom or anywhere else, okay?" He's playing with a stick. How freaking cute. That is a very cute pussy. Well, that's not uncommon. On February 28th, Murphy entered an administrative order in the interest of the safety and security of its judges, special commissioners, hearing officers, and other court personnel. The administrative order further explained that plaintiff is an obstinate visitor, is banned from the Torrance County District Court unless appearing for a hearing or having specific court business, and must be escorted by the Torrance County Sheriff's Office while in the building. On March 1, 2023, Springer received a letter notifying him they should continue with plaintiff instead of switching it out. I mean, just be consistent. Springer or plaintiff, pick one. Received a letter notifying him the court staff were being harassed on his behalf and provided him a copy of the administrative order. Document 1, paragraph 15 and 19. See document 1, exhibit 2. What did I miss in document 1, exhibit 2? Let's find out. Because they both say So they're saying that, that's the copy of the administrative order he was provided. Oh, here we go. Court staff are being harassed on your behalf. Okay. But nothing about phone calls. So again, it's still a lie, but it just says court staff are being harassed on your behalf. Okay. So he has interpreted phone calls. When plaintiff visited the Torrance County Courthouse in March of 2023, the court clerk, Ms. Rossingall, asked plaintiff where is law enforcement. So for all those of you who want to do call floods, you can see that it will impact things, not necessarily to the benefit of the person you're call flooding on behalf of, just so you know. One other thing, it doesn't say that because people that staff are being harassed on your behalf, that this is issuing. It just says it's been brought to my attention. And Jason Jones doesn't speak for the court as to why, because he's a court executive officer. I don't want to fuck cats, thank you. Kitty Key's back. Oh, come on, Morty. You pussy. Morty. It's ignoring me now, like a cat. All right. So Jason Jones can't explain why the court did it. He just says it's been brought to his attention, not the court's, but the court executive officer, who's not a judge. He's just like the chief clerk. When plaintiff visited the Torrance County Courthouse in March 2023, the court clerk, Ms. Rossingall, asked plaintiff where his law enforcement escort was pursuant to the administrative order. Plaintiff responded, yeah, I'm pretty sure prostitution is illegal in Mexico. I don't know if you're trying to solicit me right now, but I don't appreciate it. As a matter of fact, I think I'll head over to the sheriff's department right now and let them know you're trying to solicit me. Is that what you're doing? Mr. Rossingall gave a copy of the administrative order to plaintiff, who remarked, I don't know what sua sponte is. I don't know what that is. I think it's something to do with a hooker they're trying to have walk around the courthouse with me. Sua sponte. Must have been something that was said, not something that was written. Mr. Springer also entered the Moriarty Magistrate Court for non-court business. Court staff and personnel reported he was being disruptive and threatening in the courthouse. Court amended the order to include courthouses in Torrance County, Catrone County, Socorro County, and Sierra County. Mr. Springer was removed from a hearing over which Murphy was presiding. Poff entered an order excluding presence in a specific cause. DV is a domestic violence case, citing that Mr. Springer was still banned from the Torrance County Courthouse and specifically banning him from the hearing. Plaintiff filed his complaint. Again, fucking hell. Same errors. Well, there's no space there now. So oh my God. They hurt my brain. Plaintiff's complaint named the 7th Judicial District Court, yada, yada, as defendants. Plaintiff asserts he was provided notice through email, that he has provided notice through email to the 7th Judicial District Court's proposed text email. The court ordered plaintiff shall serve has a specific meaning. The complaint summons a TRO motion and this order on the appropriate defendants. Plaintiff filed a summons returns for the 7th Judicial District Court alleging service through Susan Rossingall. A summons return for Jason Jones alleging personal service at the 7th Judicial District Court. For Murphy alleging personal service at the 7th Judicial Court. And for Poff, 7th Judicial District Court. And Rossingall, personal service. In estancia. Plaintiff filed a certificate of service stating the order directing service and setting briefing schedule was served via Chief Judge Murphy proposed text email on June 21, 2023. The affidavit of service by Michael Tinker said the order directing service and setting briefing schedule was served on the court clerk at the 7th Judicial Court in Estancia, New Mexico on June 9th. On August 8th, plaintiff filed a notice of completion of briefing on plaintiff's motion for temporary restraining order. In support of the motion, he attached his declaration of James Springer. 2 of the videos plaintiff referenced in his declaration are no longer available. On August 15th, undersigned counsel filed an entry of appearance for defendants. On August 21, the court entered a second order amending briefing schedule, permitting defendants to file a response. Counsel for defendants served plaintiff's counsel a preservation letter on August 29th to preserve all evidence related to this matter. The day after service of the preservation letter, plaintiff stated that he deleted evidence. This is a YouTube video, which is really why, if you're in the middle of litigation, you should not comment on the litigation on YouTube, especially if you're dumb enough to say that you, as a habit, delete evidence, even though you know that there's an ongoing lawsuit where that evidence might be relevant. Hello, Kitty. Hello, Kitty. You come up on the table? Kitty's up on the table. Hey, Morty. Hey, Morty. How you doing? Hey, doing, kitty, kitty. Oh, you let me pet you. How you doing, kitty, kitty, kitty? Hi. Hi. Yeah. You like patents, huh? You like your head scorched? You like your head scorched, huh? Yeah. Yeah. Say hi. Say hi. Oh, you can see his ear there a little bit. Yeah. 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 This is Morty. Hey, Morty. Here's Morty's butthole. Here's Morty's butthole. You guys like Morty's butthole? Yeah. Here's Morty's butthole. Hi, Morty. You're showing everybody your butthole. Yeah. Enjoy the butthole, ladies and gentlemen. It used to be dogs' buttholes, and now you're getting a cat's butthole. Isn't that right? Huh? Isn't that right? Yeah. Yeah. Little purr guy. Little purr guy. Little purr guy. All right. Let's get off. There we go. All right. All right, where were we? So defendants filed their response to complaint, yada yada. Plaintiff filed his reply in support of motion for temporary restraining order. You're going to get to listen to a cat. Ah, Jesus Christ. And we're stepping on things. Come on, get off there. Get off there, Morty. Get off there. Get. Kitty, kitty. Thank you, kitty, kitty. All right. Sorry about that. Sorry, not sorry about that. All right. What were we doing? Andy's back. Andy's back. Why are you back? Why are you back? Excuse this interruption. I have to play with my pussy, apparently. All right. Let's see if we can't... Where were we? Yes. Defendants filed their response to complaint for declaratory judgment and injunctive relief, yada, yada. Plaintiff filed his reply in support of motion for temporary restraining order and preliminary injunction, and the court entered its order denying plaintiff's request for a temporary restraining order. Plaintiff filed a motion for reconsideration. After granting the reconsideration motion in part, the court later entered an amended order denying plaintiff's request for a temporary restraining order. Legal argument. You're going to kill me here, kid. Defendants are entitled to dismissal of plaintiff's complaint because, no, not on the keyboard. Not on the keyboard. And things just went blunk. Oh, boy. Oh, boy. You got to go. You got to go. All right. Sorry. And he's back. You are adorable. A, plaintiff has not properly served defendants. The Federal Rules of Civil Procedure establishes service of process for individuals and governmental defendants. Plaintiff's first option under Rule 4J is to deliver a copy of the summons complaint to defendant's chief executive officer. Here, plaintiff served Ms. Rossingall personally. Plaintiff attempted to serve the 7th Judicial District Court through Ms. Rossingall. However, the 7th Judicial District Court was not served delivering a copy of the summons of the complaint to its chief executive officer nor is prescribed by the state of New Mexico's laws for serving a summons or the like process on state-created governmental organization. And honey, no, no. Oh boy. And the dogs are out. Who let the dogs out? Dogs are very interested in the cat. Hold on a second. We need to resolve the situation here. All right. I apologize. I apologize for that. The dogs still really love to chase the cats, and I didn't want the cat to get trapped up here on the table when the dogs came out, so we had to rectify that situation. Cats are very good at getting away. They go up trees. They've got their own little area in the cold greenhouse to get into that's safe from dogs. So just making sure that the pussy didn't get all tore up. If the pussy is going to get tore up, I like to be the one tearing it up. All right, where were we? Plaintiff alleges that Murphy, Poff, and Jones were personally served. It is unclear who other than Rossignol was personally served, although it appears that plaintiff attempted to serve Murphy, Poff, and Jones through Ms. Rossignol or other persons not authorized to accept service on their behalf. However, the New Mexico rules of civil procedure do not authorize a court clerk to accept service for the court or court officer, official, or employee. By contrast, those same rules authorize a county clerk to be served for a county and for a city clerk to be served for a municipal corporation. The rule expressly designate a particular officer to whom process must be delivered and with whom it may be left, and provide no other substitute. Because plaintiff attempted to serve the summons and complaint to an individual not authorized to accept service on defendant's behalf, plaintiff has failed to satisfy the rules of civil procedure. Accordingly, plaintiff has not shown effective service on the 7th Judicial District Court, Murphy, Poff, and Jones under Rule 4E nor 4J. Their delivery attempts are insufficient for the purpose of service of process. Under the FRCP, the 7th Judicial District Court must be served by delivering a copy of the summons complaint to its chief executive officer. Under New Mexico service rules, the 7th Judicial District Court must be served by delivering a copy of the process to the head of the 7th Judicial District Court, which is the chief judge. With respect to Murphy, Poff, and Jones, they must be served by delivering a copy of the process to the officer, official, or employee. I guess we don't proofread. Plaintiff states that a copy of the complaint in summonus, were first delivered to the 7th Judicial District Court's clerk. Plaintiff further states that a pre-filed copy of the complaint was sent to Chief Judge Murphy's proposed text email address on June 8th, 2023, that a filed copy of the complaint as an exhibit to a motion to stay the contempt proceedings was sent to Chief Judge Murphy's proposed text email address on June 9th and June 12th, and that a filed copy of the complaint and order directing service and setting briefing schedule was sent to Chief Judge Murphy's proposed text email address on June 21. However, a courtesy copy via email fails to meet the meaning of delivery for purposes of service. Duh. That's why I was fucking laughing my ass off when he tried to serve her by email. Delivery under FRCP 4J2 requires the use of a process server. Delivery cannot be accomplished by use of certified mail. Other jurisdictions have similarly rejected also mailing to be delivery. Courts have generally held that delivery as a term of art requires more than service by mail. Yada yada. Equivalently, email is insufficient under Rule 1-004H because mail is insufficient for service for Federal Rule 4J. Therefore, plaintiff has not met his burden to show service on a designated registered agent, the chief executive officer, and or any other person authorized by law to accept service of process. C, plaintiff has not served the Attorney General. The second option for service is to serve a summons and complaint on the Attorney General. We don't really care. We know he didn't try to serve the Attorney General. Plaintiffs are entitled to dismissal of plaintiff's complaint because the plaintiff did not serve defendants within the 90 days of filing his complaint. Well, I think he served one, so that's a problem. FRCP 4M. Surfith is one of these guys who is completely blinded by his own bias against the courts. Like there is nothing that you could ever say to him that would make him think at all that any government entity, agent, or official was not completely 100% wrong. He will never understand. He cannot bring himself to use his brain enough to understand why things are happening. For him, it's all evil. They're just evil. Like everything they do is evil. There's no rhyme, reason, or merit. Any decision that they make is in violation of the orders or the violation of the rules or laws, and they're just doing it because they're evil. And he never understands that, like, sometimes cops lose, and sometimes cities lose, and the courts are actually reasonably, not completely, but reasonably impartial. I mean, that's why people sue, you ignorant buffoon. That's why people sue cities and police officers for these things. That's literally why it happens. Now, James has chosen to sue judges for monetary damages, and I don't know how the fuck that's going to go down. See, so let's just assume, arguendo, that the judge in the Pink Camera Magic case stepped down. Let's just assume he stepped down. Now, Surfith is saying he's doing it to avoid an ethics complaint. There's nothing unethical about the court making the decision it made. And in fact, the proper response for a court making a decision in a case that you don't like is to appeal, which Pink Camera Magic did. And she didn't win on appeal, she settled. So you're wrong and you're dumb and you don't even understand it. It frustrates me how biased you are. You're as bad as the anti-frauditors. who just like all frauditors are bad all the time and all cops are good all the time. You're the mirror image of that. All cops are bad all the time. All frauditors are good all the time. You're ignorant, and you have no desire to release yourself from your bondage of ignorance. Sometimes the cops are right. Sometimes the courts are right. More often than not, the courts are right. And almost exclusively, you're wrong. Ethics complaint for a decision. You're fucking retarded, Surfith. You are fucking retarded. The odds of that court that judge getting an ethics complaint. Well, getting the ethics complaint is one thing, but having anything come of that ethics, every time a fucking butthurt piece of shit like you, every time one of you fuckwads lose in court, you want to go crying, oh, ethics complaint. Ugh. They get them all the time. And the judges don't even see 99.9% of them. Don't even see them because this is bullshit. You know, I had dumb pieces of shit like you trying to brigade me, and like Earl Warden and who's that fuckwit? Chauncey Hollingberry submitting like they were showing me, they were sending these things to me, the complaints that they were making to the state bar about me. You know how many of those I saw? Zero. I saw none of them. You know why I saw none of them? Because they completely lacked merit. Just like a court getting an ethics complaint for ruling against a litigant. Just like it. So the court would never have seen it. And the court would not, the judge would not step down to avoid it. Because the judge wouldn't give a fuck because you'd never see it. So FRCP 4M requires complaints be served within 90 days after the complaint is filed with the court. Accordingly, the plaintiff was required to serve defendants with his complaint by September 7th. It was filed June 9 plus 90 days. As discussed above, plaintiff has not effectuated service on defendants. I thought they agreed that he served Rossingall personally, which means yes. So I don't know about that. Is this only certain defendants that they're talking about? So they're saying that he hasn't shown effective service on 7th Judicial District Court, Murphy, Poff, and Jones. But Rossingall was personally served. But you just said he stepped down, you dumb fuck. You said he stepped down. Judges retire. Post hoc ergo propter hoc arguments fail. Just logically. A post hoc ergo propter hoc argument is shitty. He stepped down, therefore it must have been because Pink Hammer Magic filed an ethics complaint. No, absolutely not. Absolutely not. You're dumb. And your mother dresses you funny. So that's going to be interesting. All right. So I don't know how they get past Rossingall. So it looks like it should be dismissed for everybody but Rossingall. Defendants are entitled to dismissal of plaintiff's complaint because plaintiff did not serve defense within 90 days. Yada yada. All right. Murphy, Poff, Jones, and Rossingall are entitled to dismiss of all claims against them because plaintiff fails to allege how they personally participated in the actions giving rise to plaintiff's claims. I thought Murphy signed the orders. Yeah, there's the order. Interesting. Well, let's see what this argument brings. It is axiomatic that to prevail on a damages claim for a constitutional violation pursuant to 1983, plaintiff must show that the defendant, acting under color of law, personally participated in the alleged violation. Hi, buddy. Oh, scorch the ears. The plaintiff must show defendant personally participating in the alleged violation, and conclusory allegations are not sufficient to state a constitutional violation. Must establish a deliberate, intentional act on the part of the defendant to violate the plaintiff's legal rights. 10th Circuit is clear that regarding cumulative defendants, do not establish individual capacity and participation. Court evaluated a claim where an inmate pled guilty to false imprisonment, served time in a correctional facility. When he was released, his probation officer directed him to register as a sex offender. The plaintiff sued to be removed from the sex offender registry and the sex offender section of the probation department. He prevailed. He then brought a suit against the Secretary of Corrections and the probation officer, both in their official capacities and individual capacities. Among other rulings, the district court denied the Secretary's motion to dismiss. On appeal, 10th Circuit found that broad claims stated against groups of defendants do not establish individual claims against the Secretary. That sounds like they're arguing backwards. So the probation officer did the thing, and he brought suit against the Secretary of Corrections and the probation officer. It would be akin to him saying that Poff or Murphy or Jones did a thing, and then suing the 7th Judicial District Court. So they're backwards. They're backwards on it. Because he has specifically alleged, like, just for example, here's Murphy's signature. He has attached this to his complaint and said that this violated his due process, substantive and procedural due process rights. So that's a shit argument. A review of the complaint illustrates a lack of allegations regarding the type of participation required to establish individual capacity liability. The complaint makes general conclusory assertions for relief against Murphy, Poff, Jones, and Rossingall, but does not assert any factual claims of liability. Plaintiff does not identify specific actions beyond conclusory allegations without supporting factual averments taken by particular defendants that could form the basis of a constitutional violation. This is a terrible argument. I don't see defense winning on this. It is difficult to understand against whom plaintiff alleges his claims or what factual allegations support those claims. Well, it's not that fucking hard to suss out. It's not that fucking hard to suss out. I don't see this is a terrible fucking argument. Plaintiff, it's difficult to understand him. In count one, he alleges claim under 1983 predicated on violations of First Amendment rights to freedom of the press and speech. Plaintiff alleges that Murphy and Murdoch Poff Murphy engaged in discrimination by banning and excluding plaintiff from public places and hearings, prohibiting him from attending and reporting on public matters. Okay. So there's Murphy and Poff, not Poff Murphy, fucking idiots. Moreover, the remaining defendants are not named in count one heading, and plaintiff did not plead any facts supporting claims against them. Okay. Nor are there any factual allegations pled in the complaint concerning any First Amendment violations committed, only conclusory statements. Okay. Probably. I mean, that's usually an issue, but we'll go on, I guess. Plaintiff alleges retaliatory actions, but similarly fails to plead any factual allegations concerning retaliatory actions. It is unclear what actions Murphy and Murdoch Poff Murphy. Oh, when you don't know the names of your own clients, it's really fucking irritating. It's unclear of what actions Murphy and Poff took that could be characterized as viewpoint discrimination, or what conduct were retaliatory actions, much less how plaintiff was allegedly injured. Chickens charging are fucking hilarious. On multiple dates, Rossigal has either refused service in the clerk's office or has required police presence to harass and intimidate him. Outright refusal to accept plaintiff's request for service on June 8th. And Miss Rossigal requiring that the sheriff chase plaintiff from the building, which he did. So count 1 is apparently against Murphy and Poff. Count 2, plaintiffs plural, dumbass. Count 2 is poorly worded. It doesn't say who it's against or what specific facts support a substantive due process claim. Rossigal didn't issue an order, so that's an issue. All right, so it doesn't appear that he has stated any cause of action against Jason Jones. Rossigal, I don't see what she did either. Yeah, okay. I see where they're going. So count 2, yeah, that is perfect. Count 3 does not specify it's against who it's against. Jones is named in count 3. Did I miss that? Oops. Jones is named in count 3. Jones didn't issue an order, and Rossigal didn't issue an order. Yeah, so there is no order issued by Jones or Rossigal. He fucking mailed. Oops, shit. He fucking mailed it. That's it. He just fucking mailed it. I don't like. No factual. Okay. All right. Qualified immunity. So the judges have judicial immunity. So Murphy and Poff have judicial immunity. Jones and Rossigal, I don't know that they have qualified immunity because they don't have discretionary. They don't have discretion in performing their jobs. Plaintiff has not pointed to any binding precedent or weight of persuasive authority demonstrating that a reasonable court official in Murphy, Poff, Jones, or Rossigal's position would know that limiting his access to the Seventh Judicial Court in light of his persistent misconduct would violate his rights. So the problem that I'm foreseeing is that they keep phrasing this as qualified immunity, but this isn't qualified immunity. It's a different standard. Judicial immunity looks at did the judge make this decision as part of his role as a judge in adjudicating a case. Now, if the judge is making an administrative decision, like determining who to hire for his clerk, or where to order from, or like where to order supplies from, or uh, something like that. Something that is not part of his job as a judge in a case. Like if he's doing something, if he's making a order in a case or a decision in a case, judicial immunity is going to apply. If it's something outside of a case or something outside of what a judge should be doing, like there was a case where a uh, a judge in a family law matter decided to go and inspect. There were allegations that the marital assets, like the furnishings, weren't being properly divided. So the court decided to go down and supervise the division of these assets. If I remember correctly, it's something like that. Well, judicial immunity didn't apply there because she was doing something that she's not allowed to do. She's not allowed to take an active role investigating a case. She's supposed to be a judge. The facts are presented and argued, and then she determines what the facts are. She's not supposed to be investigating. So judicial immunity didn't apply there. But it's a completely different standard than qualified immunity. So I don't know why we're arguing qualified immunity. And there's no argument. There is no argument for judicial immunity. That is, why isn't there an argument for judicial immunity? Why are they arguing qualified immunity? Qualified immunity doesn't apply to the actions of a clerk. There has to be some discretion in qualified immunity. Oh, Christ. This is Bradley versus Fisher, United States Supreme Court case from 1871. For it is a general principle of the highest importance to the proper administration of justice that a judicial officer, in exercising the authority vested in him, shall be free to act upon his own convictions without apprehension of personal consequences to himself. Liability to answer to everyone who might feel himself aggrieved by the action of the judge would be inconsistent with the possession of this freedom and would thus destroy that independence, without which no judiciary can be either respectable or useful. Uh, The principle, which exempts judges of superior or general authority from liability in a civil action for acts done by them in exercise of their judicial functions, obtains in all countries where there is any well-ordered system of jurisprudence. It has been the settled doctrine in the English courts for many centuries and has never been denied that we are aware of in courts of this country. It has a deep root in common law. Nor can this exemption of the judges from civil liability be affected by the motives with which their judicial acts are performed. See, this goes back to Surfith's dumb shittery about you step down to avoid an ethics complaint for trying her for filming in the courthouse. Judicial immunity applies. This has always been the case in the United States. It has always been the case. Always. They are exempt from civil liability. And I guess an ethics complaint would not be civil liability, but it would still, they still have to have the freedom to make the decisions. The underlying uh, purpose for the judicial immunity from civil liability would still apply because they need to be free to act upon their own convictions without apprehension of personal consequences to themselves, not just in the civil matter, but ethics complaints. And then what about 42 USC 1983? What about that case? What about that case? What about that? There is, except that in any action brought against a judicial officer for an act or omission taken in such officer's judicial capacity, injunctive relief shall not be granted unless a declaratory decree was violated or declaratory relief was unavailable. So you can't sue a judge under 42 USC 1983 for injunctive relief unless declaratory relief was violated or declaratory relief was unavailable. And judicial immunity prohibits you from suing a judge acting in their official capacity for monetary damages. So monetary damages out, injunctive relief, generally speaking, out. Your proper course is if you're seeking injunctive relief and the court denies it, you appeal that denial. That is the appropriate course of action. You don't sue the fucking judge. Fucking Christ. I can't fucking believe that they didn't mention that in this case. They didn't mention the part about the injunctive relief in this case. It's not available. They didn't mention judicial immunity, that declaratory damages isn't available. And people say, "Oh, you think you're the best fucking attorney ever." I'm not. But like, this is basic shit. This is basic shit that they're missing. You can't sue a judge for monetary damages because you didn't like the order the judge made in your case. You can't sue for injunctive reliefs, generally speaking, because your proper course of action is to appeal the denial of the injunctive relief you requested. And this stupid fucking defense attorney didn't even raise this. Did not even raise it. Talking about qualified fucking immunity. Like a goddamn idiot. Fucking Christ. I mean, I don't have a dog in this fight. James's attorney's a fucking retard. This attorney's a fucking retard. It's a battle of retards. It's a fight to the bottom. Oh, Christ. The complaint should be dismissed because court does not have jurisdiction. Rooker-Feldman, they don't have jurisdiction to challenges to state court decisions, in particular cases arising out of judicial proceedings, even if those challenges allege the state's court's action was unconstitutional. Under the Rooker-Feldman doctrine, lower federal courts are precluded from exercising appellate jurisdiction over final state court judgments. If the state court decision was wrong, that did not make the judgment void, but merely left it open to reversal or modification in appropriate and timely appellate proceeding. Okay, so that's valid. They're saying that Freeman should appeal the court's orders in the lower court case. Fair enough. The federal doctrine applies. The federal case brought by state court losers complaining of injuries caused by state court judgments rendered before the district court proceedings commenced and inviting district court review and rejection of those judgments. Sure, fair enough. Although an argument could be made that these aren't judgments in cases. These are special this is an administrative order. This isn't a judgment. So the problem I still see on this is I don't know where James Freeman was ever served notice before this administrative order proceeded. He lost rights to be someplace without notice and an opportunity to be heard. Unless unless somewhere they're going to allege that he actually did receive notice of this. But the argument can be made, is this administrative order, is this a judgment or a lower court thing? Is this something that is even appealable under state law? I don't know if it is. I don't know if there is a mechanism for appealing an administrative order. Administrative orders are typically things like where a court will set like a rule for that particular court. Like administrative orders are about like dress codes for the court, or what documents you'd have to. They're generally things that don't apply to a specific person. But there is, in the matter of James Allen Springer, aka James Freeman. So, and there is a case, I don't know. So it's something that I think James Freeman's attorney should definitely distinguish. And we'll see, I guess, if he gets there. But he should definitely try to distinguish this from a. Here, the plaintiff is disputing a state court decision, specifically the administrative orders limiting his access. His claim therefore depends on the court finding state courts erred in entering the orders. Although he alleges claims under 1983 and the New Mexico Constitution, he ultimately fails to state a federal claim. The basis originates from the administrative orders due to his own matters, blah, 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 with law enforcement escort. Procedurally, the order should be reviewed by the New Mexico Court of Appeals and New Mexico Supreme Court. Let's check it out. They're saying A1B. This is A1B. Well, that'll be interesting. That will be interesting if he was supposed to. If he is supposed to appeal, if he does not have remedy at the federal court level, it will be interesting because he had 30 days to file his appeal. That will be interesting. So 30 days, so that's sometime around March 27th or 28th, 29th, March 29th. Plaintiff's complaint should be dismissed as sanction for intentional spoliation of evidence. Possibly. That argument is possible. He has a duty to preserve evidence. Yes. His deletion demonstrates culpability and intent. Yes. Spoliation of evidence prejudices defendants. Yes. So, all right. So that's that document. And then we have notice of briefings complete. Let's see if he includes anything new in there. No, he doesn't. This because he has snuck new things in notices of briefing complete. And then notice of extension of time for response. So he has till December 11th to file a response to their motion to dismiss. Okay. All right. I think that's it. I think that's it. And there's nothing new in there. And there's, see if there's anything new in this one. There's nothing new in there. All right. Well, that's it for today. Thank you for watching and have a great day.